Cases that kind of shook the world up, Harris versus State and Wiggs versus State, and for the first time questioned the legal reliability of drug dogs' superior scent. And this part because there was no standard of training or certification for those canines.
Harris and Wiggs actually were fairly recent cases from 2011 that pretty much changed the ball game from the way probable cause determinations by a court would be handled on canine sniffs. What they probably should have been questioning all along is it possible for a dog to ever indicate that it smells something or make an alert when in fact there's nothing there?
Welcome back, everybody, and now we'd like to introduce Garry Potts to our program. Mr. Potts is a former assistant state attorney in Florida. He served in that position for 15 years, where, as a prosecutor, he handled a wide variety of criminal matters, including drug sales, possession, and trafficking, and had numerous cases involving canine detection. Thank you so much for joining us, Garry. I really appreciate your being with us today.
Thank you, Al.
Let's talk about some of the legal challenges, and I'm going to start out with, because you have worked on both sides of the fence right now. Let's talk about your role as a prosecutor. When you had a case that canine dogs were used, how confident did you feel in that case? And when were those cases most likely to be used, where you would use a dog?
Well, of course, I was a prosecutor before Harris and Wiggs, primarily Harris, came out from the Florida Supreme Court. So we didn't have to present all of the track record history that Harris requires now. So I was very confident. Everybody pretty much unquestioningly believed in the canine's ability to detect drugs. I had cases, automobile cases, where there were no drugs in the trunk, even though the dog alerted, but there was some residual signs that maybe drugs had been there at one point, and it never became a real issue. But the way it really is valuable for law enforcement then and now is it allows law enforcement to get inside of a privately owned container, giving them the probable cause that the Fourth Amendment search and seizure laws require.
Okay, so you wonder what's being stretched here. Is the definition of probable cause being stretched, or are these just defense attorneys that are looking for more wiggle room in their cases?
No, actually, I think that the court system, the judges and attorneys, just really never considered the dog's ability to reliably predict whether or not there's drugs in a container. Nothing's changed other than the fact that maybe the judges realize that, well, there's no standardized training in Florida as of now, and therefore the mere fact that a dog and its handler may be certified and trained means nothing, because it doesn't say what level and extent of training they got. And so you really need to look at the dog and the handler's history of reliably predicting drugs in a container, and if it shows that that pair often look into containers based upon the dog's alert and the container's empty, then that indicates a problem with the reliability and a lack of probable cause required by the Constitution.
So you're like the two gentlemen here that are saying, yeah, give us national standards because we need them.
Well, sure. Those two cases, notably the Florida Supreme Court's case in Harris last year that required evidence of the drug dog's field performance history, came about because the court recognized that there's currently no standardized system of training in Florida. And so if you got a standardized system of training, you might find that the courts would start backing off on some of the requirements that you've got to provide these elaborate field histories.
Now, it's interesting because in the Casey Anthony case, which a lot of people watched and a lot of people saw, we actually heard some of the case histories of some of those dogs that were being used in that particular case to track on some of the scents. Will the role of the drug dog ever change in terms of not being as reliable? Are we going to be going to technology to try to replace that or not?
Well, I'm not going to predict technology, but I do know that as of now, there's no electronic sniffers as good as a dog. And when a few years ago, local forensic lab chemist actually did a test. Rather than drugs, I think they were using chemical accelerants like gasoline, and a dog could reliably detect levels of accelerant much lower than the laboratory's gas chromatograph could.
Oh, wow.
So I thought that was impressive.
Yeah, and the fact that we mentioned earlier only 1 in 63 dogs actually make it through this process to become handlers. So how do you think these cases are going to be handled in the future? And obviously it looks like this whole notion of keeping very good records is going to be a must. I mean, not only because it's required by law, but just from the standpoint of getting a good prosecution.
Right, and keep in mind this is going to be something that a judge hears. It's not going to really come in before the jury. The judge has to make a determination if the drugs that were found were obtained in accordance with search and seizure law. In other words, did law enforcement have a basis to reliably predict, more likely than not, that there's drugs in a privately owned container before they went in there? So in a courtroom, the only thing that's going to be different is, in addition to the canine and the handler's training and certification records and an explanation of what that entailed, now the trainer's going to have to provide a list of the canine's field performance record, including a list and a number of what the court will call false alerts. And you have to define false alert, but a court's going to consider that any time the dog alerted on an empty container to be a false alert for constitutional purposes. And so obviously the handler should be able to tell before they ever walk in the courtroom how successful they're going to be, because if the dog's history is that more often than not he's alerting on empty containers, your drugs aren't getting into court that day. But if you've got a dog that's far above 50%, 70% at least, I think 90% is a very good target to shoot for on reliability, then yeah, judges are going to let the drugs in just like they always have, and it's not really that much different than it has been, just a little more record keeping.
Right. So are judges more likely to be harder on the dog or on the trainer?
Well, nobody's going to be hard on a dog. Everybody loves the dog, but
okay.
Quite frankly, they're just going to be hard on the statistics.
Yeah. Now you're working on the other side, and when a drug person tries with an intent to obviously hide that they're bringing in drugs, and they have an intent to hide them from dogs, does that make it any more of a crime for them, or does the law particularly not care whether the dog finds the drug or whether humans find the drugs?
No, other than if they get bitten, which I assume doesn't happen that often in drug dog seizures, but there is no enhancement of the crime of possession or trafficking because a dog had to be used to uncover it. That's just one more technique that the government and law enforcement has available to them in order to interdict drugs.
Mm-hmm. Gentlemen, while you're sitting here, because we're talking about national standards, and Gary, I'm talking to Mark and Frank that are joining me right now, and where does the push have to come for that? Is that going to have to be legislative, or is that going to be from guys like you? Because I know you guys are passionate about getting it right. I think maybe that's the one thing I see from both of you.
Well, I think law enforcement should lead the charge. I don't think that people that are not familiar with canines and their abilities should be the ones writing all the standards. I believe law enforcement should get together in some type of effort to set some standards that are achievable and reliable for the citizens of the country.
Mm-hmm. Frank, what do you think?
I agree. And in the state of Florida, FDLE and Florida Criminal Justice Standards is currently having seminars where they're inviting the trainers throughout the state, and we're setting a standard for drug dogs in the state of Florida. Now, I do think that it's up to the state attorney's office or the actual judges to make sure that law enforcement enforces their own standards, right, and that they adhere to them, because that's a benefit to all of us.
Gary, have you seen any cases that you've worked at where law enforcement didn't maybe train as well as they should, or didn't enforce some standards that they had set up on their own?
Well, of course, until last year, there was no requirement that the law enforcement presents their field history, so it wasn't always apparent. You keep in mind also Al, that in the cases of what the courts call false alerts on an empty container, the court system and the attorneys never see those because generally there's no drugs found, so the people are just told to go away and they don't enter the court system. It's only when they find drugs, and of course at that point in retrospect it looks like, well, the dog is successful, and that's kind of an illusion, if you will, that the court system's gone under, just assuming that dogs are 100% reliable, and they never question that, well, perhaps, you know, when a dog alerts, maybe statistically it doesn't give a more likely than not probable cause prediction that there's drugs in there. Maybe sometimes the dogs are alerting when it's just residual odors and the container or vehicle are empty.
Mm-hmm. And Mark and Frank, you're both shaking your heads, so go ahead, Mark.
Well, we do keep track of all what we consider non-productive searches. In other words, anytime a canine responds to a vehicle or a container and you locate no drugs, that is made and documented, records kept of it. We also keep a record of the number of vehicles a dog searches and does not respond to. So we're training for two things. One is to locate and prove he can locate narcotics, and secondly, that the dogs will not respond to every vehicle they come to. So we document fines, we document non-alerts on vehicles, and we always document alerts on vehicles where no drugs were found, and the circumstances surrounding.
Same thing, Frank, you.
Yeah, I was going to agree. I know at the Sheriff's Office here in Pinellas County that anytime we get our dog out of the car, we write a report, whether the dog's productive or not, and with all the details of who, when, where, why, and how, so that is predictable. I have a question for Gary. Don't you agree, if we are keeping a deployment log, that we should also take into account the dog's positive finds in training as well, that the dog's doing the right thing in training? And I noticed in some of the court cases they really don't want to see training records per se as far as reliability. What do you think on what is your thoughts on that?
I think that the courts definitely will listen to that and want to hear it. One of the requirements that the Supreme Court put down is any other evidence of the dog's reliability. You know, they'd like to hear that, but I believe they're going to be a little wary of a controlled training situation. They don't know how that was set up or how used the dog may be to the course or the procedures that are used. They would rather hear how the dog does in the wild, if you will, in the actual field situation where things are unpredictable and nobody even, you know, it's like a double-blind scientific study. Not even the handler knows if there's really drugs in the trunk of that car, and the dog really is having to make a prediction. And that's what the Fourth Amendment probable cause is all about. You know, do the police reliably know with a weight of probability that there's contraband inside a container before they are allowed to go into that privately owned container?
Now, let's just also remember, Mark, you were going to say something.
I was just going to say, I agree with that, except for the fact you can't make the automatic quantum leap that a lot of attorneys want to make, that just because a dog responds to a vehicle or a container and you don't locate the drugs, you can't say 100% positive that was a false response and hold that to against a dog if his records indicate otherwise. Then just to say the dog alerted and you didn't find any narcotics would mean it's a false response, and that's absolutely incorrect. There's no way of knowing in the real world when a dog responds if you're finding the narcotics or not.
Gary, got about 20 seconds left. Dogs play a very vital role in the courts and probably always will, correct?
Absolutely. You know, one thing to keep in mind is the way you define false alert or false response. From a dog trainer and handler's point of view, if the dog alerts on residual odor and there's nothing in there, the dog was still successful. From the court's point of view, based on constitutional law, if the dog indicates that there's drugs in a container and it's empty, that's a false alert, and it did nothing to reliably predict that there was illegal contraband in there, and that's all the courts care about, even though the dog was actually doing what it was trained to do.
Yeah, kind of a sticky area. Gary, hey, thank you.